Listen to the vibes.
Welcome, everyone, to another episode of Vibes. And love to welcome here Oscar Vasquez. Now, he is the founder of estate.prep.com. And we're going to talk about wills and estate planning. And well, I've got some questions for you. Before we do that, man, let's start this off right. Tell us a little bit more about yourself.
Well, first of all, Kyle, I want to say thank you for allowing me to come on your podcast and share the
Yes.
awareness. With 68% of people of homeowners don't have an estate plan, and I think and so thank you for helping me out on this campaign
Oh,
and
yeah.
allowing me to spread the word. But I'll tell you a little bit about myself. My name is Oscar Vasquez. I'm out of Southern California. I've been in the real estate industry for 28 years, and I've been helping homeowners for the last 15 years, um, doing estate plan, helping them protect their homes from the government deciding on what happens to their home, which is probate. About 3 years ago, we started our software, and because the attorneys just started to take longer, and the costs from estate planning went from 600 to like 5,000.
Oh, wow.
So it got really expensive in California. So we made it affordable for everybody, and we got payment plans, and so that's how we got involved with it. But more, so that's where we're at, and that's how we got into the business.
Well, one of the questions that I had burning on my brain, some of us, we have elderly parents, grandparents that we're worried that they're going to pass away and they don't have a will or anything like that. You want to bring it up, but how do you do so without sounding like you're being greedy and like, oh, what am I going to get?
Well, I think that the topic, and here's the conclusion that I came up with. 68% of homeowners or people in America that meet 68% of homeowners don't have an estate plan. And they don't have an estate plan because they don't know that it exists. One. Two, they don't understand that with an estate plan, all the fundamentals that come with them, and they come with a lot of documents that's called end of life documents. And so, how you approach your loved ones is, I would say, hey, I listened to this podcast. This is something that we should really consider. And it always starts off with one, what are the things? What's going to happen if you become incapacitated? What do you want to have happen for your end of life? And when you start that conversation of what you want to have happen with the end of life, and it's called a healthcare directive. That's part of an estate plan and a living trust. But before we get into deep into the differences and all that, I want people to understand what a living trust is, because a living trust is a contract between you, the parents or the grandparents, and your children or your grandchildren that the courts help to enforce. That means it has legal provisions that make it, and that's why it's called a contract, because a contract is something that is broken if you're not followed. And I always say, in layman's terms, a living trust is the instructions to your kids on what you want to have happen with your body, or the three things that you love, or the two things that you love most. One, your your things, and your kids, right? That's the instructions on what you want to have happen, with the things that are nearest and dearest to your heart, your loved ones, and your money. So, and the courts help enforce that. However, the difference between a will and a living trust is a night and day, and it's mind-boggling, because people think it's one of the biggest myths in estate planning that a will is enough. Now, because we have a short time span, I'm going to go deep, and not go deep. I'm going to give you the very, very ugliest parts of probate. What happens to probate? And I'm going to tell you, here's what you do. Well, if you're listening to this and you want to know if you're going to go to probate, Google what is the threshold in my state. I'll give you an example. What is the threshold in Colorado? Is $60,000. In Indiana, it's $50,000. In Utah, it's $100,000, and in California, it's $184,000. That means that if your total net worth, your total collectibles, your total assets, your home, your retirement account, anything that you have, the old car in the garage, right, is still has may exceed that value in some cases. If it has that, if it exceeds that threshold of going to probate, this is what's going to happen. The first thing that's going to happen is that you're going to need to hire an attorney. If you're in California, what's going to happen is the attorney's going to come to you and it's going to say your house is worth 750,000. It's going to cost you about $40,000 to $50,000 to go to probate. But don't worry, you don't have to pay me all that money now. All you have to do is pay me when you sell the house. That means your kids, your loved ones may be forced to liquidate in order to be able to pay the cost of going to probate. One. Two, the second thing that happens is that the courts are going to publish all of your information and it's going to make it a publicly known subject that you passed, what you had, and if anybody has any claims against you or that they think they owe you money, or if you have a long lost child or somebody that feels they're a beneficiary to your assets, you're gonna come. You're gonna come to. They're gonna come to court, and the court. Now, the third thing that happens in probate that is terrible that nobody knows about is that the courts make the final decision. A will still has to go to probate. A living trust is the only document that prevents you from going to probate. So the third thing is that the judge makes the final decisions on how your assets get distributed. That's it. They make the final decision. So we have two choices. One, we make the decision on what happens to our things by having a living trust, or two, the courts decides on what happens to your things. The fourth thing that happens that many people don't realize is that the assets or the estate will not get distributed from in California. And now I did hear, I talked to a customer in Indiana. It took them 8 years to settle their estate. 8 years. Wow. And she said, by the time we got done, when we started the estate, it had 270,000. By the time all of our siblings got our money, we ended up with $5,000 apiece. Imagine that, because it was just such a long proceeding process. To settle the estate, it takes anywhere from 6 to 18 months minimum. If you have no issues and maybe it's just a collectible car, maybe that can be settled quickly because there's not. But the more assets you have, the more collectibles, the more retirements, the more real estate that we own, the more things that we own, the more valuable the estate, the longer it may take to settle, because the court wants to make sure that, one, the appropriate people get paid and the appropriate people get your assets. So that's why probate was invested. Now, the threshold, what does that mean? That means that if you have anything that exceeds that amount, the courts are going to get involved. And I think that was put into place to make sure that you can afford to pay for the courts. Right? That's why it was there. It was there to be able to protect us, but they say if you got enough assets, we want to be able to protect you. Well, so then that's where living trust and estate planning came into play. So a will, in reference, a simple will is a 2-page document. If you get 1-page document, if you get it off the internet, if you pay an attorney $300 to $400, it's probably 2 to 3 pages long. But a will is that page long, and a living trust is about 140 pages total combined with all the documents. That's the in deference's number of pages and information that's on there. 2, a will not prevent you from going to probate. A will make you still have to go to probate. So that means you still have to incur the cost. You still have to go to become public. You still have to pay. You still have to wait to get settled. And that means the court still makes the final decision. Now, I've never had it or know of any case where the judge said, oh, you're the 3 kids of the deceased, you don't get any money. I've never had that. Okay.
Right.
Never seen that. However, I have seen firsthand, not seen, I wasn't in court, but did hear. We had a gentleman that lived in Colorado, or not, Texas. He had 3 children there, came back, created a new family, and started a new family. In his will, he wanted those 4 kids from California to inherit all of the property. The judge, the kids from Texas came to the hearing and claimed that, hey, that was my father, I'm entitled. He took the estate and divided it by 7, called it a day, said next case. It was like a 5-minute hearing. Done. Right? That
Right.
was that case. So imagine you wanting to leave your assets. That's kind of like losing some of your inheritance by accident. Right?
Right.
Right? It's like, hey, waking up going like, what the hell happened? So that's what I mean by the judge can do whatever what's out there. Now, if there's obligations and everything out there, the living trust protects you from the debt, because it's you own nothing, but you control everything on there. But the biggest misconception is, there's 2 biggest misconceptions. One, a will is enough, and 2, the big that you have to be wealthy. And I always tell people when they say, I'm not, that's for the rich. And I say, listen, if you own a home in the greatest country in the world, in my opinion, this is the greatest country, because it's given me things that is beyond belief.
Amen.
Yeah. And I say that if you own a home, you are wealthy, right? Well, the way I'm going to say, you are rich, because wealthy is only in your heart, because money don't make you happy. It's what's in your heart that makes you wealthy, right?
Right.
So, and I truly believe that. So I say, if you meet that threshold, you need an estate plan. You need to, and I always tell people, now that you know what probate is, imagine what's going to happen to your things.
Mm.
Amazing,
So,
huh, Kyle?
like, exactly. So, let's say like my mother, who now owns my grandparents' property,
Right.
um, and we live here in the greatest state in the union, Texas. Um, she passes away, and let's say she wants to leave this to me. I don't have any other living siblings. So, but she needs to do an estate plan, make sure like her car and everything else. She might want the car to go to my kids. I don't
Sure.
I don't know. So she
Right.
needs to do an estate plan instead of just a plain will.
Yeah, and the reason why, because what's going to happen is, if you don't do an estate plan, she's going to have, there's a possibility of tax consequences to you. Because I'll give you an example. Let's just say grandma bought it for $10,000,
Hmm.
and now, and I'm gonna just use a random number, 100,000, whatever grandma paid for the house, and then mom had it, and now she wants you to have it, but then something happens in your life, right? And you decide that you have to sell it. You're going to pay, there's a possibility that you're going to have to pay the taxes from what grandma paid and what you're selling it for. That means half of your assets get depleted into taxes. And those are some of the tax consequences that happen. Now, in every state has different provisions. When you have an estate plan across the board, across every state of the land, it becomes a new tax basis. Mom passes, son, now let's just say when mom passes, the house is now worth $500,000. That $500,000 now becomes the new tax basis. If you sell it for 6, you only pay that capital gains tax. Well, I like using 45, but California is the highest state. I mean, we're the only place in America that we can eat out of a paper bag and pay $25. You know,
Right.
you know what I mean? It costs. I mean, it is what it is. But the cost basis now turns into 500. Now, if that property you do an estate plan, and if mom, when she creates an estate plan, she says, if son dies, I want it to go to my grandchildren.
Mm-hmm.
That means if you don't take the property out of the estate plan, it'll automatically go to your children when you die. And you don't have to create an estate plan because that is a benefit for them.
Right.
And then that the tax basis then becomes when you die. So now it starts to increase because nothing's ever going to be as cheap as it was yesterday. Not it ain't
Right.
going to happen. I mean, I when I first started selling real estate in our small town, well, I remember homes were $82,000. Now those same homes are $780,000, and it's been less than 30 years. Like,
Crazy.
what the heck happened to us?
Right.
But that's the world we live in, right? But you
Right.
know, so there is the things that not preparing it. So people don't realize. Now, I've seen a lot of cases where they want to get into an estate plan. They want to get into an estate plan. However, when they inherited the property, it wasn't properly transferred, and the title company won't take it. Now they have to go back and do the proper paperwork, and sometimes that requires a hearing. And that means a judge to say that, you know what, you got title correctly. There's nobody else. Is there any other siblings? It makes things a lot easier, quicker, and simpler for the courts when there's only one or two children and they come forward and they say, hey, we agree. This is how it should have been. If there's more people, then what happens if there's five and each one had five kids and now three of the five died? Now those other kids have a word because they, by inheritance, by legacy, by levels, they now have a benefit that was their father's that they have to divide. But now you have to deal with five more people,
Right.
right?
Right.
And so not preparing, I mean, it's kind of like, it's like the conspiracy thing, right? The best conspiracy is the conspiracy of one. Right?
Right.
Because it's easier to make and it's easier to do it by yourself from when it's there. So those are the things that most people don't realize. One, they don't know that an estate plan is going to protect their kids. That's the first thing. The second thing, the additional documents that come for end of life. And I'll give you one of the ones that most people don't realize that in our great country we have a lot of privacy laws, and that's called HIPAA. And the
Mm-hmm.
healthcare privacy laws means that if your mother or your father or your loved ones are adults and they go in, even your child, let's say your child turns 18 today, tomorrow they get in a car accident, they become incapacitated, they cannot give you their health care records if they did not sign off and give you that right because they are now adults.
Ah.
So one of the end of life documents is called a HIPAA waiver. That gives you permission to get a second opinion to be able to save your child's life, or to, if you agree with, if you get, dealt a bad hand by giving you a bad hand by getting a bad doctor that you don't see eye to eye with, or you don't communicate with, or he's not being responsive to your demands or information that you want, you get the HIPAA waiver, you pull it out, you get copies, and you go get a second opinion. So you're 100% comfortable. That in itself makes every mom think about why they should do an estate plan. That one document. However, if there's additional documents, it's called a healthcare directive. If she's income now, and they say, look, well, don't the hospital do that? Yeah, they give you those documents when you show up. Say, hey, if an emergency happens, who do you want us to contact? Well, that part of that emergency form is the healthcare directive. Like, who's going to make decisions if you become unconscious, right? And you don't
Right.
do that. That's who that is. But if you show up unconscious and it's not filled out, right? Now, I did have a case. I did have a family member of a client that we dove. They didn't have an estate plan. We dove deep and we came up with a creative way and saying, "Hey, she's been in that hospital more than once,
Mm-hmm.
and we want you guys to pull those records. And because she pulled those records, she every time they came in, she signed a healthcare directive and a HIPAA waiver, and she always put the same child on there. And they said, well,
Right.
how is that? Why can't you use that to release us the information? Because she's done it more than once, right?
Right. Right.
And so they threatened to sue if they didn't give up the records. Oh man, they uh they hand over those records real quick. But it's imagine the one, your mother's unconscious, you don't know what's going on, you're not happy with the decisions or the information they're giving you, and now you need to come up with this idea on how you're going to get these records. If you had an estate plan, it prevents all that from happening.
Right.
Now that is the probably the, I mean, God forbids that we never want to be in that situation, but it's one of those things like insurance. You're damned if you have it. You're damn, and you're not damned if you have it with insurance if you don't use it. But if it expires and you didn't use it, you kind of feel you threw money away. But man, you are sure happy when the tornado came and you had tornado insurance, right? Or the
Right.
earth. So that would be that one. And then you also have another document. Not you have the healthcare directive, the HIPAA waiver, and another document, which is called the end of life document, which means what happens to your body, and do you want to be cremated or do you want to be buried? And if so, if you want to be buried, where do you want your place of rest to be? Right.
Right.
Um, I had a friend of mine, and he was in Texas. We just bury him in the backyard, bro. We everybody's in the backyard. I said, yeah, I'm not talking about the enemies. I'm talking about your loved ones. And he goes, oh, we bury them all back there. No, just kidding. And he's always talking to me that he lives in Houston. He's always talking to me about moving back to Texas because he goes, man, I don't know how you put up with that, right? I don't know how
Right.
you know what, I my wife, I got to convince her. But anyways, so back to estate planning. So those are some of the documents, and then you also have what's called, I'll give you an example, a financial power of attorney that comes with it. And the financial power of attorney gives you the ability to be able to pay the taxes, pay the bills from her account, from her assets for her. And there's what's called a spendthrift provision. And the spendthrift provision limits your children to spend the things that are absolutely necessary for you and that are common for your spend. So
Right.
they can't go buy a lottery ticket. They're not going to go buy a Corvette or a truck or anything like that to with your money. But the that capacity is a is a um, is a financial power of attorney that dies with you, and then the living trust clicks in.
And in the case of if I was to be unconscious
Uh-huh.
and something that I don't know, let's say I was going to be a vegetable,
Yeah,
and I've told my wife, hey, I don't want to be on any feeding tubes or breathing apparatus. If I can't breathe on my own and it doesn't look like I'm going to come out of it, I just as soon just let me go.
yeah.
I need
That's
I need to really have it documented, not just tell her that's what I want.
that, and here's the reason why. Because in your in your end of life document, you have, are you pro life or right to die,
See,
right?
and I've already said, in fact, every time I've gone into the hospital and I've had to have a procedure, doesn't even matter if it's a small procedure, I always sign a DNR.
That's right. That's right. And that's our beliefs. That's our right. And if you have it in your estate plan, that makes your I mean, imagine if you don't know. Imagine if you never had that conversation with your wife. What's the burden you're leaving on her? Like, oh my God, what about if I pull the plug and he wakes up? Right? Like, I got you. It's that reminds me of that. There was a show it was a TikTok thing, but the guy that was drinking, he was drinking. The comic is out of Tennessee, but that reminds me of that. where the guy was always drinking, the guy blacked out, and then when he woke up, they made a room that looked like a hospital bed and said, "Man, you've been unconscious for 20 years." And they're like, everybody was stressed. And they were like, he's like, really? He goes, yeah. He goes, man, I should stop drinking, huh? He's like, I was gonna wake up and have a beer. But anyways, that reminded me of that. But no, but so imagine the burden, the burden that you're gonna leave left off of your loved ones by having that document, because it's in writing, you signed it. Um, and let's just say, for example, your your wife knows, but your kids didn't know, and mom does that, and your kids go like, "Why would you do that to dad?" That could devastate the whole relationship by them not knowing. Say, "What you did? You killed dad." No, no, that's what he wanted. How did no? That's not true, and they could not know, right? And that
Exactly.
could devastate for generations to come. Could change the trajectory of the relationship forever by not having one simple document. And
Mhm.
and I always say that, I mean, that, yeah, it is extreme, but man, we're in a world of extreme right now, man. I mean,
That ain't no lie.
I got a 28-year-old that can't get out of the house without 4 jackets. I'm like, what the hell's the matter with you, boy? But but it is what it is. So I share that because those are all the things that estate planning, and I'm serious when I say estate planning is for two. It's to protect the two things that should be nearest and dearest to your heart, and that's to protect your family and your money. Because
Mhm.
I get the most common question at workshop is, what can I put into my living trust? What assets? And I say, well, I'll break it down to you in the simplest terms. Anything that you can't take with you.
Right.
Right? And anything you can take with you, you don't have to put it in. And if you can take it with you when you pass, then you can exclude that.
I'm sure there's people out there that's watching this or listening to this. They may have questions I didn't think of. Do you have maybe an email
Yeah.
or something they can ask you a
Yeah, what
question?
I'm gonna give you an 80, the phone number is 805-909-4689. That is a artificial intelligence estate planning coordinator. She's there to answer questions and educate 24 hours a day. Just don't call her while you're driving, because she'll send you a ticket. No, just kidding. But you could call her 24 hours a day. At the end of the call, after she says, "Do you have any more questions?" she'll ask you two questions. One, would you like to speak to a live person? Or two, would you like to schedule a call? If you say no, she's not going to insist. She's there for the education purposes only, to make sure that all your questions get answered. One. The second,
Awesome.
and then I also have a free comprehensive living trust guide. I call it comprehensive because, and I recommend everybody download that guide. And here's why. Because you can do, like most people say, how long does it take to do a trust? You can do it in 45 minutes without the human delay, because there's questions on there that we never thought about. And
Mm.
when you have a spouse, you like go like, man, what's going to happen with that, right? Well, we never thought of that, you know. And so that's the human delay. And I started to create that a comprehensive living trust, so that way you can carry it with you, and the questions that are on there that are there. So go into there. It's estate.prep.com /guide. That is for that. Now, for those of you that are listening that absolutely need it, and know that you meet the threshold, that you did your homework, you Googled what's the threshold in my state, and you meet that threshold, we're going to give you the first 10 people that take action. We're going to give you a discount code and the discount code is T Vibes. T Vibes is the discount code, and we'll put it in the show note. I'll send it to you so you can have it. The first 10 people will save a lifetime value. Now, it's a lifetime value because when you use our software, you can update it as many times as you want for no extra charge. An average attorney, now I'm going to do a quick comparison. I know that's my sign that we got to go, but if the comparison is this: an attorney is going to charge you an average national average from Tennessee to Alabama, because I like using them because those are the lower income states and those where things are a lot more affordable. The dollar goes a little bit further there, but on average, the national average is $3,500 to create an estate plan, average to $10,000 and up. Our estate plan, we sell them all day long for our website at $2,500. But for if you use the discount code, you'll save $1,000. The second reason why ours is completely different is the simple fact that every time you need to make a change or something happens in your life, an attorney is going to charge you $1,200 to $1,800 to do an update on your trust. With our software, you have unlimited trust. Because we are nationwide, because you're nationwide, you have to pay $129 a year the year that you make the update. And the reason why is because we hire attorneys in each state to update our trust so they're compliant. So every year there's a new law, a new provision, a new situation, we update it. So we do that on a yearly basis, and that's $127 compared to $1,800. And I always tell people this: the younger you are, the more money you're going to save because things only go up. So I tell you, with that, the 14 and your checkout would be $1,495. If you need a payment plan, we have payment plans available for you, right? And we start on your living trust available. We are so flexible; it's not even funny. There's no reason not to. Wait. There's only one reason I can think of not having an estate plan, and that's that your kids aren't very nice to you. Just you hate your kids. Well, I always tell my kids this, I turn off all the lights. I go, do you guys hate me? You guys have all the lights all day long here watching 9 TV. So, but that's the only reason. And I say that, and Kyle, thank you for helping me bring awareness to the country that we love so much about estate planning and why you need it.
Oh man, I appreciate you. You answered some questions for me. And I, like you mentioned before, I will put all your links in the description. Oscar, thank you so much, man. I really, really do appreciate you coming on.
Thank you so much for having me.
And I also want to thank all you folks out there. If you are new to the channel, I hope you'll come back. Please hit that subscribe button. For my regulars, you guys are awesome because you make it possible for me to do this. Until the next one, everyone, please take care. Be kind to one another. God bless and peace.
We hope you enjoyed this episode of Listen to the Vibes. You can catch us on Buzzsprout or wherever you listen to your favorite podcasts, and on YouTube. Follow us on Facebook at The Vibes Broadcast Network